It is with immense pleasure and privilege that I welcome you to day two of the workshop series on forensic evidence, organized by Goa State Legal Services Authority in association with High Court Bar Association of Goa. We are profoundly honored this evening to be graced by the distinguished presence of Justice Valmiki Menezes, the chairperson of High Court Legal Services Committee and the judge of the High Court of Bombay at Goa. He is also credited for the meticulous planning of this workshop. Justice Ashish Chavan, the judge of the High Court of Bombay at Goa. Justice Sriram Sirsat, judge of the High Court of Bombay at Goa. We also extend a very warm welcome to Ms. Shabnam Sheikh, the esteemed member secretary of Goa State Legal Services Authority, our president, Mr. Zilman Coel Pereira, the principal district judges, the judges of various courts, and my dear junior colleagues and senior colleagues, both present in person as well as online. As we anticipate with great eagerness today's session on DNA evidence, it is only fitting that we acknowledge the invaluable contribution of National Legal Services Authority. In that spirit, may I request all of you to maintain dignified silence while we play the Nalsa theme song in Konkani. Yash, please go ahead.
सगळ्यां खातीर मळब न्यायाचे सगळ्यां खातीर अनन्यायाचो सगळ्यां खातीर विश्वास न्यायाचो सगळ्यां खातीर आमच्या ह्या भारत देशाचेर हक्क आमचोय आसा न्यायाच्या ह्या आसऱ्याचेर हक्क आमचोय बी आसा मुठभर मळबाचेर हक्क आमचोय बी आसा मुठभर मळबाचेर हक्क आमचोय बी आसा
अशें समजू नाकात दुखणें आमचें खंयच आयकचें ना आतां न्यायालय स्वता चावडे मेरेन येतलें
निराधारांक न्याय मेळटलो दुखेस्तांकय बी न्याय मेळटलो दिनदुबळ्यांकय बी न्याय मेळटलो देशाचेर हक्क आमचोय बी आसा उमेदीच्या ह्या फुलबागेचेर हक्क आमचोय बी आसा मुठभर मळबाचेर हक्क आमचोय बी आसा मुठभर मळबाचेर हक्क आमचोय बी आसा
गरीब आणि दुबळ्यांक फुकट तसोच घटमूट कायद्याचो पालव दिवपाक बांदील आसा विधिक्त सेवा प्राधिकरण नालसा न्याय सगळ्यां खातीर
Thank you, Yash. It is now my privilege to invite Ms. Deepika Tiwari to the dais. Ms. Deepika Tiwari is a distinguished scientific DNA officer at the Forensic Science Laboratory. Please. With over 11 years of dedicated expertise in DNA fingerprinting, she has examined and reported upon more than 900 exhibits in cases ranging from rape and murder to paternity disputes. Today, she shall enlighten us on the nuanced process of collection and analysis of DNA evidence.
Thank you, ma'am. Good evening to all the honorable judges and other dignitaries. I'm Deepika Tiwari. Today, we are going to talk about DNA fingerprinting, from its evolution to the current practices which we are following in India. Now, let's talk about what is the objective of scientific examination. When we talk about scientific examination, especially in forensic science, it is to uncover the truth. Unlike assumptions or personal opinions, science relies on facts, logic, and evidence. Many times, evidence is not visible with our naked eyes. It is hidden in traces, like in DNA, fingerprints, blood stains, or digital data. Through scientific methods, we are able to reveal these hidden clues and present them in a reliable manner before the court of law. This ensures that justice is not based on doubt, but on truth. That is why we say truth alone triumphs on the basis of hidden evidences. This presentation will give us a brief insight into how DNA forensic has developed and how it plays a crucial role in strengthening our justice delivery system. Now, when DNA was not into the picture, we were completely relying on the biological examinations. Biology division played a crucial role in criminal investigations. Biological and serological examinations were used to study the stains, hair, botanical samples, blood grouping, and species origin. These are the scope of biology division, where we can do the grouping with wet, dried blood stains, semen stains, hair examination. Physically, we can examine the hair. Saliva examination, we can also do paternity, maternity on the basis of ABO grouping, and then species identification and diatems examination in case of drowning. Before getting to the ABO blood grouping, now we have to understand who started this, who has given us this knowledge of ABO grouping. So he was Karl Landsteiner, who discovered the ABO grouping in 1900. Earlier 20th century, until DNA fingerprinting came into the picture, the criminal justice was relying on the blood grouping. First case of the paternity was solved on the basis of blood grouping in 1912 in Austria. This is the inheritance pattern of ABO blood group. Now on the left side, we can see this is the father's blood group. And on the top, we can see that is the mother's blood type. So in the columns, we can see if the father is having these blood groups and the mother is having those blood groups. So these are the combinations which are possible in their offspring. Let's say if the father's blood group is AB and mother is also having blood group of AB. So the offspring can have A, B, AB or O. So accordingly, we are able to find what will be the blood group of offspring if their mother and father are having these blood groups. So these patterns were used when we were doing the paternity analysis during the biological evidences time. Now, 1994, 2003, we were completely relying on, as I told, biological examinations. In 2003 and onwards, so I'm talking about the India. So from 2003 onwards, we are completely shifted to the DNA examination because we know the gravity of the DNA examination. And that is the reason we shifted here. Now, This is the scope of DNA division. What are the samples we can examine in DNA? We can examine blood sample, semen sample, saliva sample, bone, hair, it has root in it, tissue samples, product of conception, fetus, nails, etc. Now we are talking about the DNA, but who discovered the DNA? Let's talk about its history first. So in 1869, Frederick Mischer discovered the nuclein. He said there is something which is present inside a cell, and he named it nuclein. It means it was a genetic material. We call it DNA today. Now in 1953, we were aware, okay, now there is something present which is inside the nucleus. We were not aware about the structure. So here comes the Watson and Crick, who told us what the structure of DNA is, how it looks like, and how it plays a role in transferring the genetic information from parents to the offspring. Now, the revolution came in 1984 when British professor Alec Jeffrey, he introduced DNA fingerprinting in criminal justice system. So he was the man who introduced this technique into the criminal justice system, and today we are because of him, we are doing DNA profiling, and we are able to do the DNA examination. Now, before we proceed further, we should know what is DNA. So now in this diagram, here, this is the chromosome. So when we open the chromosome, these are thread-like structures which are present, and these threads are wrapped around on a spherical structure. These are histone proteins. Now on the histone proteins, the threads are wrapping around, and when you open it further, we can see this is a double helical structure. And when we open it further, we can see there are bases, nitrogenous bases we call it, A, T, G, C, so on. So these are the bases which are responsible for the DNA fingerprinting. Now, DNA came into the picture. Now we know, okay, DNA is there. Now, what are the techniques we were using when we were doing the DNA fingerprinting in the for the criminal cases? So we were using the technique restriction fragment length polymorphism. We call it RFLP. So RFLP, basically, it is a technique where we use endonuclease restriction endonuclease enzyme, which cuts the DNA at specific sites. We can also call it like biological scissors. So let's say we have a thread, and that endonuclease enzyme will cut it at different places. And then accordingly, we'll get the fragments of the DNA. Now, on that fragment will run those fragments on the gel. Maybe it is quite technical, but I'll try to give you that picture that we are running those fragments on a gel. So let's say the fragment which is smaller in size will run faster, and the fragment which has larger in size will move slowly. So according to their size, they will separate and the band will form. In the next picture, this is the RFLP analysis in paternity testing. So here we can see these are the bands. These are nothing but the strands of the DNA, which we have cut by using those enzymes. Now, by analyzing these strands, these fragments, we can analyze whether the, see, this is the case of paternity. So this is the bands which we have got from the child. And this is the band of mother. And now male 1, male 2, and male 3. When we observe, we can see the child's band is matching with the male 2. And this is how we were concluding the paternity by using the RFLP technique. But it was quite lengthy. And the one thing was, the limitation was we need a DNA in a very good quality and quantity. Now, the revolution came when the STR came into the picture. Now, what is STR? So today, the DNA profiling, whatever we are doing in the DNA, we are doing the STR profiling. We call it STR profiling. So what are STR? STR are short tandem repeats. So basically, these are the repeats of various lengths that are present in everybody's DNA. And those are unique in everybody's DNA. So let's say in the picture, we can see, here. So these are the repeats. Now GATA, GATA is the repeats in the DNA segment, in the fragment. Now here in the first strand, we can see the number of repeat is 4. But in the second, we can see number of fragments are 1, 2, 2, 3, 4, 5, and 6. I mean, number of repeats are 6. So it means in one person, the repeat would be 4, but the another person, the repeat would be 6. So this is how we differentiate one profile from the another on the basis of STRs. Now, this is the first identification of accused that was proved on the basis of DNA profiling. This was the first time in history when we solved a case by using the DNA profiling. So it is very interesting case. What happened? A murder and assault, rape happened to a teenage in 1983. And the second rape and murder happened in 1986, after 3 years. Then the police, they searched for the evidence, and the semen stains were present on the crime scene from the body of the victim. They found that both the semen stains are of the same person, and that is of A group. Grouping can also be done through semen. So it was found that group is A. Then the police, they arrested one person named Buckland because he was seen nearby the crime scene. So police, by intense questioning, they convinced him, and he confessed, okay, I did the second crime, but he said, I did the second crime, but not the first crime. He take the accountability for the second one, but somehow police managed, and then he said, okay, I have done both the crimes. Now, when the trial was going on, the investigation agencies, they approached the Alec Jeffrey for the DNA fingerprinting. Now, Alec Jeffrey, when he did the DNA fingerprinting, what he found is the DNA which was obtained from the crime scene is not of the Buckland, the person whom the police has arrested. So when that report goes to the court, then they declare, okay, this person is innocent. And that was the first time when exoneration happened on the basis of DNA profiling. Now, they did the DNA profiling of 4,582 men across the 3 villages. They collected all the blood samples of the person who were living there around age 17 to 35. And then Colin Pitchfork was found guilty, and his blood sample DNA matched with the crime scene samples. And this is how the conviction happened. So this is quite interesting case. Now, DNA fingerprinting in India. In India, Dr. Lalji Singh, known as the father of DNA fingerprinting in India, he solved the first case of paternity on the basis of DNA profiling in Tamil Nadu. And he also established CDFD in Hyderabad. Now, let's talk about the Goa FSL. In Goa also, we have a DNA division, which was established in October 2023. These are with the collective efforts efforts and support of Home Department, police authorities, and Director FSL Goa, with financial support of Central Nirbhaya Fund, MHA, Government of India, we were able to open this division. And October 2023, we opened the division. Case reporting was commenced in February 2024. 140 cases, which includes 900 plus exhibits, has been done. 0 pendency we have maintained, and we are reporting the cases within the period of 1 month time, especially the POXO cases and the rape cases. The role of the DNA division. So we are doing the criminal cases which involve identification of the perpetrator in the rape, identification of biological stains, murder, assault, identification of the missing person, and the cases which are under Child Protection Acts. Now, when we talk about the DNA fingerprinting, there are 3 components which come into the picture. The first is biology. So when we are doing the DNA extraction, we are extracting the DNA from a cell. And cell is what? Cell is a biological component. So when we are extracting the DNA, we are doing biology. When we are applying technology into it, like RFLP, like PCR, so those are the implementation of the technology. So first we use the biology, second we use the technology. Third, the genetics comes into the picture, because we are continuously talking about the DNA fragments and we are doing the STR typing. So basically we are dealing with the genome and we are doing the STR typing that comes into the genetics. So 3 components, because of these 3 components, we are able to do the DNA profiling. This is the protocol of the DNA analysis. First, we have to extract the DNA from the sample. After extraction, we quantify the DNA. Then PCR amplification. genotypic analysis, comparison, and interpretation. In the upcoming slide, we'll discuss each of them in detail. So this is the first step, DNA extraction. As the name suggests, we are extracting the DNA from a cell. So when I say extracting, it means there is a cell and we have to remove everything from that cell except the nucleus. So we add some chemicals which will break down the cell wall, the proteins, the lipids, and other debris from the cell, and we would be able to get the DNA out of it. There are two methods which we are using, and in most of the FSLs, they use the organic extraction and automate extraction. So automate, as the name suggests, automatic instrument is involved in it, and organic extraction, these standard chemicals like phenol, chloroform are used, and then we are able to get the DNA out of it. Next step comes the quantification. Now, when we are saying quantification, what is the need of quantification? Because when we have isolated the DNA, we do not know whether DNA has been isolated or not, and what is the exact quantity in that particular isolated sample. So we have to check the quantity. How we are going to do that? We have a dedicated instrument for that. We call it RT-PCR, and then it will tell you the quantity, exact quantity of the DNA that is present in the extracted sample. It will also tell you the inhibition, if there is any inhibitor present, or if the sample is degraded, that will be known by this process. And then what is the benefit of this? When we know the exact quantity, we can use the sample accordingly for the upcoming process. Third steps comes the polymerase chain reaction, PCR. But before talking about the PCR, let's talk about who invented this particular technique. Because PCR was something which enhanced the DNA fingerprinting. How? Because when we were doing RFLP was basically, that was a laborious process and we were doing it manually. But here, when PCR came into the picture, we were able to amplify the DNA in a very rapid manner. So let's say if we have a small quantity of the DNA, in the upcoming slide, we'll discuss that. First, talk about this. So it was invented by Cary Mullis in 1985. So here, this is the instrument which is shown in the picture, which performs the PCR. We call it thermal cycler. Now, this is the PCR amplification I was talking about. Now, this is the tube where we put the DNA. And then we put the buffer. There are DNTPs, then primers and Taq polymerase. So these are the ingredients which are required to perform the PCRs. Why? The Taq polymerase, as I said, it will act as a catalyst, you can say. Now, the primers, it will bind to the specific region. Now, the primers will bind, and now DNTPs, which are present in the solution, they will start binding further when the primer is bounded that particular desired strand of the DNA. Now there is a buffer to maintain the condition of that components, and then there is a DNA. After mixing all these ingredients, we put this PCR tube into the instrument, and this is thermal cycler. So it will provide the cooling and heating in a cyclic manner, and that is the reason we are calling it thermal cycler. And after each cycle, there will be the copies of DNA will multiply. And at the end, after 29 to 30 cycle, we are able to get million of copies of DNA. So what is the use? Let's say if the DNA is in very less quantity, we can make the multiple copies of it, and then we can get the complete profile. Now, this is the genotype analysis. This instrument, we call it genetic analyzer. Now, this instrument, it based on the principle of capillary electrophoresis. It produces a graphic data, which we call DNA profile. And humans have 2 alleles per STR locus. We'll explain it in the next slide. And each allele is defined by the number of repeats. Number of repeats we have already discussed. So, number of repeats of the STR sequence. Now, these are the kits which we are using for the PCR amplification and for the genotypic analysis. They have the markers. So different kits have, some kits have 24 markers, some have 27, some has 26. The more the marker, the more will be we can say there is, we can easily differentiate between the samples. Now, this is the graphical DNA data. In this, we can see the green one. These are the markers. Now this, the peaks. And here in the box, there is a number. So there are 2 peaks. It means one peak, it means one repeat is coming from, allele is coming from the father and the other is coming from the mother. And the number which is written in the box, it is a number of repeats. Like here it is 11 and 12. So it means that on that particular marker, that repeat is 11 times and 12 times. So we can, here, because we do not have the profile of mother and father, so we can say one has come from the father. So maybe father has 11 or maybe the mother has 11, the next comes from the father. This is the data interpretation in case of paternity. Now here we can see the first one is of victim. The middle one is of the baby, and the third one, which I have highlighted with the blue, is of accused profile. Now, these are the number of repeats, which we have already discussed. So, these are the number of STR repeated 6 times. So, that is the reason 6 is written here. In the baby, there is 1, 6 and 1, 9. It means 1, 6 is coming from the mother and 9 is coming from the father, the first row. Similarly, in each and every row, we can see 1 is from the mother and 1 is from the father. And we can say one complete set is coming from the mother. So we can say that victim is the biological mother and one complete set is coming from the accused. So we can say he is the biological father of the child. Now this is the data interpretation in sexual assault case. The first one is the profile which we have got from the clothes of victim. The second one is the suspect 1, suspect 2, suspect 3, and then suspect 4. Here we can see the profile which we have got from the clothes of victim is exactly same with the suspect 1. All the repeats are same. 6, 7, then 12, 13, 28, 33.2, 14, 21, so on. So this is exact same. So we can see the accused first, the suspect 1 was involved in this particular crime. Now, we were talking about the DNA profiling. So there are 3 types of profiling which we do. One is autosomal. So the profile we were discussing earlier, those were autosomal. So autosomal means that profile has come from the autosomal chromosome. It means one comes from the father, one comes from the mother in that particular set. YSTR, as the name suggests, it is coming from the Y, means male. It can give you the lineage, paternal lineage, but it cannot give you the proper identification. You cannot identify a person. You cannot exactly confirm that, okay, this is the profile of this person, but you can confirm the lineage. It means, let's say, if somebody, we have got one body which is unclaimed and somebody is coming and saying he is my brother. So we can do Y profiling and then we can find the lineage. And if the YSTR is same, we can say, yes, it is of the same paternal lineage. But again, we cannot tell the exact relation, whether it is cousin brother or just immediate brother. We cannot reveal that. We cannot tell that. Next comes the mitochondrial DNA, mitochondrial analysis. So mitochondria comes from the mother side only. So when we talk about the mitochondria, it means it will give you the maternal lineage. The last one is next generation sequencing. It is the upcoming technology. So it will, here you can sequence the entire genome and we can check the mutation on single base, on the even single base. But currently we are not using it. Now these are the DNA profiling kits which we used for the YSTR. Again, the markers, it has 27 markers, it has 23, sorry. So again, the number of markers will give you the more clear picture of that particular profile. YSTR analysis. So this is just for the helping. We can say this will help you in proving a case or in interpreting a result. Let's say if there is a gang rape and there is a mixture of 4 or 5 accused persons, then we can do the Y. So Y would be different of each individual, each male. So then accordingly, we can tell ki, okay, this person was involved, this person was not involved. So that will be a helpful additional with the autosomal profile. But again, autosomal profile is the must. This is just for the support. Now, why we are doing this workshop, why we are focusing on the DNA thing? Because obviously the crime has been increased. But not only crime, especially the sexual assault cases has been increased. 87 rapes are reported daily. Over 7% rise in crime against women was reported in 2019 as per NCRB data. Now, these were the cases, receipt of cases across the FSLs. So initially 2011 to 2014, we can see the cases were coming to the biology division. Then when people got to know about the DNA, the gravity of the DNA, and then certainty that is present in the DNA examination, the shift is there. The cases were coming in the DNA more. And everybody now needs the DNA, whether it is a murder case, whether it is a sexual assault case. Obviously, when there is a certainty, we always know, we always need that certainty has to be in our report. Now, these are the some of the cases in India that set the landmark for the DNA profiling. Swami Premanand case, 1994, DNA test confirmed Premanand's involvement in multiple rapes. Naina Sahani Tandoor case, 1995, body identification done through DNA. And Priyadarshini Matto case, 1996, DNA matched semen samples. Nirbhaya case, which is very famous. Again, our this contract has been funded by Nirbhaya. 2012, DNA conclusively linked accused. Now the database. In India, we do not have database right now. It is in process. But in US, they have their database. We call it CODIS, Combined DNA Index System. UK also has its database, ND. India, again, it is in development process. Soon we'll be having it. And I think it will be very helpful for the justice delivery system. Now, this is the interaction between the three components of the criminal justice system. Again, this is very important part because we all three are equally responsible when it comes to the justice. It is not the responsibility of anyone. It is the collective efforts of every stakeholder, like law enforcement, scientific analysis, and legal proceedings. So law enforcement, when the police collect the exhibit and they are sending it to the lab. And being a scientific expert, we have the responsibility to utilize those evidences in a correct manner, and we have to validate those evidences scientifically so that that can be produced in the front of court. And then court gives the judgment on the basis of those reports. So if anything is lacking behind, justice cannot be delivered on time. So we have to work together, we have to work hand in hand so that everything will be in place and justice can be delivered. Now, recently in 2025, Supreme Court in this particular case, Kattavelai alias Devakar versus State of Tamil Nadu, Supreme Court has provided some guidelines that covers collection, preservation, admissibility of DNA evidence. Key points include maintaining mandatory chain of custody. Again, we hear a lot that because of the chain of custody was not maintained, so after being positive result from the FSL, the conviction couldn't happen. So again, chain of custody plays a very important role when it comes to the justice system. Ensuring timely transport of samples to the forensic laboratories. Let's say if you have collected the sample, but you are keeping it in the police station, you are not submitting it in the FSL on time, and that sample become degraded with time. So obviously a scientific expert cannot do the examination properly. So again, submission, collection, and then submission, and then sending it to the FSL on time is a very important role. That has been highlighted by the Supreme Court of India. They have also given the instructions for strict sealing. Sealing has to be proper just to maintain the chain of custody. Now we can see that biology and serology laid the foundation for identification of individual on the basis of forensic stains on the basis of biological stains in forensic. And today DNA is the gold standard, which not only punishes the criminal but also exonerates the innocent one. Now, to fully harness the power of DNA in justice delivery, we need to expand and modernize forensic labs across the country. Investment in infrastructure will ensure faster and more reliable reporting. Equally important is the requirement for nationwide training programs for police, for doctors, for forensic staff, so that evidence is collected, preserved, and analyzed correctly. Finally, there is need to promote public awareness and legal literacy around DNA fingerprinting. People should know the value, the power of the DNA fingerprinting, and also their responsibilities concerning DNA evidence. In the end, I would like to say that forensic science is not just about the science, it is about the justice. DNA has become the voice of the silent evidences, ensuring that truth alone triumphs. With stronger system, better training, and collective efforts, we can make sure justice is not delayed and never denied. Thank you.
Thank you, Ms. Tiwari, for lucidly elucidating the intricacies of DNA evidence. I'm certain that your exposition shall significantly aid the justice delivery system in arriving at a clearer and more scientifically grounded conclusions in criminal cases. I now call upon Justice Ashish Chavan on through the days. Justice Chavan, prior to his elevation to the bench, practiced criminal law with distinction since 1999. He also imparted his knowledge as visiting faculty in the diploma program in forensic science and criminal law at St. Xavier's College, Bombay. This evening, Justice Chavan shall enlighten us with his perspective on the legal contours of scientific evidence pertaining to DNA. Sir, the stage is yours.
Good evening to all of you. And after that very enlightening lecture on the scientific aspect of DNA profiling, actually it makes my task very easier, which is why I had requested the organizers to have that lecture before mine, so that the nitty-gritty of what DNA is all about and how does DNA extraction from the time of its extraction till the time of the final opinion, how does the entire journey progress? Once we understand it a little better from the scientist's perspective, then it becomes easier for us to digest and understand it from the legal perspective. And so I will, without much ado, I will start on the evolution of law pertaining to DNA evidence and its use in both the criminal investigation systems as well as the other aspects of how DNA has been used and how courts have looked at it, how the law has generally been interpreted and evolved. I had tried to simplify what DNA is. It's a tongue twisting kind of a name. It's deoxyribonucleic acid, but leave that aside. Basically, it's like a twisted rope ladder, which is how the first or second slide that Tiwari madam had just shown. And it is something which is extremely unique to every person. So my DNA is obviously going to be absolutely different from yours, which is why, or it's like a fingerprint. But again, fingerprint may have its own inadequacies. This is going a step further and saying that DNA of one person is virtually, it is next to impossible to have it as same as to another person, save and except for identical twins. Now that is a very interesting feature. But save and except for identical twins, you can't have same DNA of two individual human beings. Why is it important in law? Because of this unique aspect, of this unique characteristic that no two persons can have the same DNA, it becomes extremely important for criminal investigation from that perspective. And it is broadly used, as we understand it, in two areas. One is criminal investigations and one is paternity suits. So DNA from the child can be cross-matched with that of the parents to establish the parentage of the child. That is one area where DNA profiling is required, utilized, and there are a number of case laws on from the Indian jurisprudence perspective on this aspect. The other one is, of course, DNA profiling, which we are all very familiar with. Comparison of a suspect's DNA profile to the DNA material found at the scene of a crime. So these are broadly the two areas where we see DNA profiling and DNA tests being conducted. A little bit of a history of DNA profiling it's already been told to you. I'll just look at it with a lawyer's perspective or the legal perspective. In 1984, British genetic scientist Alec Jeffreys develops a process for DNA profiling. And in 1986, this technique is put to test for the first time, where it helps him to crack a murder case, which we just discussed. It's that pitchfork case. And where an innocent person or a person who was unconnected to the crime had confessed to the murder, and the DNA profiling actually showed that he was innocent. In 1990, the first commercial DNA profiling kit was developed. Now, what is the process of DNA profiling? I won't dilate on that because it's already been so lucidly and clearly explained to you. We will straight away go on to the judgments on DNA evidence and their impact on the evolution of law. We go back to 1991, where for the first time in the judgment of Kuniraman versus Manoj, I will be sharing all these judgments and their citations. So let us right now just go through this whole narrative and understand how the law has evolved. Then all those judgments can be shared with you. So in 1991, for the first time, the Kerala High Court had this question of a maintenance application of a lady who claims to have fathered or mothered the child of a person who was her paramour. And the question, the complicated question that arose before the court was whether this science can be utilized to find out the paternity of the child. And normally I'm not in the habit of reading paras from judgments, but these judgments are so lucidly written that it is rather, very interesting how the court looked at this entire set of facts and how, he finally reached a conclusion that yes, as a scientific method, DNA can be utilized to arrive at a conclusion here. So I'll just read, just smart excerpts from the judgment. The para 1 of the judgment basically deals with the facts, which I will not bother you with because I've already explained what the facts are. Para 11 gives a short, I should say, introduction about what DNA is. So again, that is a lot of science. The tools, so this is something interesting. The two tools of molecular biology are essential in the preparation of DNA fingerprint of an individual. First is a DNA probe, which is simply a short sketch of a single-stranded DNA, like all DNA, which is made of a particular sequence of letters or bases. A probe works as a basic characteristics of a DNA structure. It binds with DNA strand having complementary sequences of letters. A probe of known sequence and labeled with a radioactive isotope acts like a bloodhound seeking out in a thicket of DNA its matching sequence. A DNA probe can be pieced from a DNA isolated from an organism or synthesized in laboratory. Pioneer scientist in developing DNA fingerprint technology, Dr. Alec Jeffrey, used a particular probe in his study of variation in human population and got them patented. The second tool is a group of enzymes called restriction endonucleases. These enzymes work as chemical scissors that cut into a length of DNA wherever they see a specific short sequence. Now, after a lot of this a repetition of scientific phenomenon of how DNA is a very effective tool, we come across the evidence in this case, which is again very interesting. PW number 4, the witness who was examined in that case, was a senior scientist attached to the Center for Cellular and Molecular Biology, Hyderabad. And this center is still doing absolute sterling work in the field of DNA profiling. Who, according to the prosecution, is an authority on the subject. He had experience in the University of Edinburgh. In collaboration with him in the CCMB, a DNA fingerprint technique is being developed by using a probe isolated from the DNA of a poisonous Indian snake and designated as 8 kilometers. I don't know whether this is correct, but it could be a typo also. Results are said to be much more encouraging and foolproof. He says that CCMB perfected the technique in 1988 and that it is 100% sure. He agrees with him, stating reasons also. Many authoritative articles on the subject were also proved by him. The reason why I'm going a little deep into this is for the first time in 1991 that an Indian court is looking at the efficacy of DNA profiling, which is why we must try to understand how the law looks at it. So he collects the required blood from the concerned person, that is the putative father, that is his name is Kuni Raman. He says that all the tests mentioned above were conducted with perfect accuracy. When DNA profile of Manoj is the child whose DNA is sought to be examined and compared with the parents, was compared with that of Kuni Raman and Vilasini, he found that every band in DNA profile of Manoj is either derived from the DNA profile of Kuni Raman, that is the father, or Vilasini, that is the mother. For this reason, he finds that they are the biological parents of Manoj. That is the opinion given by PW4 in so-and-so exhibit and in the box, and his opinion is fully confirmed by the CW1, supported by many authoritative articles. So the expert not only gives his opinion, he also corroborates it with number of authoritative articles. Mixed DNA profile of Kuni Raman and Manoj and the separate profile of Kuni Raman also confirms that all the 9 bands shown by the arrows in the photograph, which is at exhibit P7, are those bands which Manoj inherits from Kuni Raman, that is the father. DNA patterns, so and so. Again, there is a lot of scientific discussion. At the end, and this is the first time that the court takes cognizance of all of this, it says that the chance of Kuni Raman being unrelated to Manoj, but happens to share all the 15 bands, is 1 in 300 billion. Whereas the present world population is less than 6 billion. This is, of course, in 1991. He also said that prior to DNA tests as a preliminary examination, alleles for ABM, MN, RH, ESD, EAP, ADA, these are other tests, and HB polymorphic systems of the blood of all 3 persons were also analyzed, and the results of all these tests were also indicative that Kuni Raman is the biological father of Manoj. So the court is not resting only on DNA evidence, it is seeking corroboration with other tests also. These are facts spoken to by so-and-so, noted in so-and-so. Nobody else in the world could be found with identical pattern which the alleged father has contributed to the child, and the only possibility of error is in the case of monozygotic, that is developed from the same zygote, twins. So that is what I told at the very beginning of my speech, that unless and until you have identical twins, there is no possibility of error. And the facts in that case eliminated the possibility of the identical twin, which is why the court now comes to a definite conclusion that Kuni Raman alone could be the biological father of the child, and that his conclusion is 100% foolproof. So this is for the first time that in a paternity suit in India, in Kerala, a court has held that yes, DNA may not be infallible. I wouldn't use the word infallible, but yes, to a certain high level of accuracy, DNA is an excellent tool for arriving at a conclusion whether the paternity can be established or not. Now, this is the first time this was used. Let us see the first time when it was used in a criminal case. We also saw Naina Sahni murder case. So I don't know whether anybody remembers, way back in 1994, this was a very gruesome murder of a paramour by trying to burn her. Of course, it was an attempt to burn her, so it was all the more gruesome. Burn her in a barbecue or a tandoor. And subsequently, a DNA test was done. This was the infamous Naina Sahani tandoor murder case. The DNA test was done to confirm the identity of the dead body of Naina Sahani. So more or less, we are in 1994, the timeline is now 1994, and the court comes to a conclusion that yes, the remains of deceased Naina Sahani matched with the DNA that was available, and the presence of the accused otherwise also was there, and there were other corroborative material which ultimately pinpointed to the fact that the murder of Naina Sahani was committed by her paramour. Then the next time this came into the fore was Priyadarshini Mattu rape and murder. Again, a very, very gruesome, very, very gory kind of crime where an LLB student again was brutally raped and murdered by someone whom she was in a relationship with. The DNA analysis of that semen stains from the site with the blood taken from the accused established his presence on the site. Now, very interestingly, the Supreme Court, now here is the first time that the Supreme Court has taken cognizance of the tool of DNA in criminal investigation. And this is what it has to say. Again, I'll paraphrase it. We now come to the circumstance with regard to the comparison of the semen stains with the blood taken from the appellant. The trial court had found against the prosecution on this aspect. So the trial court holds against the prosecution and acquits the accused, and ultimately this travels to the Supreme Court. In this connection, we must emphasize that the court cannot substitute its own opinion for that of an expert, more particularly in a science such as DNA profiling, which is a recent development. Then it quotes I would say the father of DNA profiling in India, that is Dr. Lalji Singh, who himself was a witness in that particular case. He was also a witness in the earlier case that I have spoken of, Naina Sahani's case. So he, in his examination in chief, deposes that he had been involved in DNA technology for since the year 1974. He had returned to India in 1987, joined CCMB Hyderabad, developed indigenous methods and techniques for DNA fingerprinting, which were now being used across the country. Then it quotes the judgment, it cross-references a judgment of Kamalanath versus State of Tamil Nadu, where again Dr. Lalji Singh was the expert witness. The court also notices that he's a scientist of equal repute, and he had in fact conducted the tests under the supervision of Dr. Lalji Singh. So we have got a protege of Dr. Lalji Singh here who's conducting the tests. It was not even disputed before us during the course of arguments that these two scientists were persons of eminence, and the laboratory in question was also held in the highest esteem in India. The statements of the scientists reveal that the samples has been tested as per the procedure developed by the laboratory. Samples were sufficient for the purposes of comparison. No possibility of these samples having been contaminated or tampered with. Two scientists gave very comprehensive statements supported by documents that DNA of the semen stains on the swabs and slides and the undergarments of the deceased and the blood samples of the appellant were from a single source, and that source was the appellant. So a very clear-cut finding. Then the trial court evidence was looked at. The court observes, trial court was not justified in rejecting the DNA report as nothing adverse could be pointed out against the two experts who had submitted it. We must therefore accept the DNA report as being scientifically accurate and an exact science as held by this court in Kamti Devi versus Poshiram. So again, a cross-reference to another Delhi High Court judgment. In arriving at its conclusions, the trial court was also influenced by the fact that the semen swabs and slides and the blood samples of the appellant had not been kept in proper custody and had been tampered with, as already indicated above. We are of the opinion that the trial court was an error on this score. So here it differs with the trial court, because the trial court, considering that judgment, the other cross-reference judgment here, came to a conclusion that there was no proper handling and the chain of custody was not properly maintained. But here the Supreme Court says in this facts of the case, it is not so. So we accordingly endorse the conclusions, etc. And finally, yes, these are the ones. So here is where, for the first time, that the Supreme Court has had an occasion to comment exhaustively on the efficacy of DNA as a tool for aiding investigation, criminal investigation. Then the next in line is a judgment of 2014. again of the Supreme Court, where the name of the citation or the name of the judgment is State of Gujarat versus Kishanbhai and others. Again, the value of DNA evidence was underscored, and the observations, again, I'm trying to paraphrase them, not reading out. The court says it has been a great advancement in scientific investigation on the instant aspect of the matter. The investigating agency ought to have sought DNA profiling of the blood samples. So here the court is lamenting the fact that it was not done. DNA profiling was not done, which would have given a clear picture whether or not the blood of the victim so-and-so was in fact on the clothes of the respondent so-and-so. This scientific investigation would have unquestionably determined whether or not the respondent accused was linked with the crime. Additionally, DNA profiling on the blood found on the knife used in the commission of the crime would have uncontrovertibly determined whether or not the said knife had been used for severing the legs of the victim to remove her. Again, a very, very gory fact where a 6-year-old girl, her legs were amputated only for the purpose of robbing her anklets. In spite of so much advancement in the field of forensic science, the investigating agency seriously erred in not carrying out an effective investigation, etc. So again, the Supreme Court has an occasion to sound a cautionary note at why these excellent tools which are now available at our disposal are not being used by the investigating agency. The next, again in line, is of the same year, 2014. This is Rahul versus State of Delhi. Sorry, it is 2023. And the Supreme Court now sounds a cautionary note on the other side. See, this is how law is evolving. Initially, we have a lot of judgments on the efficacy of DNA. And now we are coming to the fact of how the Supreme Court or how law looks at the other aspects of it, the veracity of it, the maintenance of the chain of custody, the preservation, and all those aspects are now, because as law evolves, we see that it has got multifarious dimensions. So once DNA investigation was accepted in a lot of cases, then there arose this question of certain lacunas, which is where for the first time the Supreme Court says, this is again, I'm just pointing out in short, but this is a slightly divergent, not divergent, I would say this is again a cautionary note on the other side. In this regard, it's very pertinent to make in this regard, very pertinent observations are made by this court in Manoj versus MP, another cross-reference, which has an occasion to deal with the issue of DNA profiling methodology and statistical analysis. And then there is again a lot of scientific discussion. What is deoxyribonucleic acid, etc.? I will not dilate on that. Then the court has gone deep into DNA profiling methodology, etc., which we have already seen, statistical analysis, collection and preservation, which is where I will pause. Collection and preservation of evidence is something which the Supreme Court very, very categorically spoke about. It says if DNA evidence is not properly documented, collected, packaged and preserved, it will not meet the legal and scientific requirements for admissibility in a court of law. Because extremely small samples of DNA can be used as evidence, and I'll repeat this, because extremely small samples of DNA can be used as evidence, greater attention to contamination issues is necessary. So because even a few micrograms of DNA can be used to effectively conduct a DNA test, which is why the standard of proof or the standard of requirement of maintaining the chain of custody is going to be higher, which is what the Supreme Court is saying. Can be contaminated when DNA from another source gets mixed with DNA relevant to the case. This can happen when someone sneezes, coughs over the evidence, touches his or her mouth, nose, or other parts of the face, etc., etc. So this is basically the part about contamination. Then it also discusses about how the ideal practice should be. And I'm quite sure that this judgment is going to be a wonderful read for anybody who's interested in how. So the Supreme Court has not only said that this is wrong, this ought not to be done, this will lead to contamination. It also goes and talks about various other cases in India and abroad where the right methods have been used and the chain of custody has been adequately maintained. It also quotes very interestingly the Law Commission. It says, so the Law Commission in its report, now this report is the 185th report on the review of the Indian Evidence Act. And it is quoting from the Law Commission, quote, DNA evidence involves comparison between genetic material thought to come from the person whose identity is an issue and a sample of genetic material from a known person. If the samples do not match, then this will prove a lack of identity because the known person and the person from whom the unknown sample is originated, if the samples match, then that does not mean that the identity is conclusively proved. Rather, an expert will be able to derive from a database of DNA samples an approximate number reflecting how often similar DNA profile or fingerprint is found. So as the science advances, we see that there are a lot of issues that are, coming up over this entire DNA profiling, DNA testing. It may be, for example, that the relevant profile is found in one person in every 1 lakh. This is described as a random occurrence ratio. Thus, DNA may be more useful for the purposes of investigation, but not for raising any presumption of identity in a court of law. So this is what I mean when I say that when scientific community or when science advances in a particular way, it advances in the 360 degrees. It doesn't advance only in 1 degree or in a one particular way. So what was considered as some kind of a magic bullet or a magic wand is now being looked at with a bit of circumspection that yes, this is an excellent tool, but it could have its inherent inadequacies also, which is what the Supreme Court is also commenting on. Then it cross-references the case of Dharamdev Yadav versus state of UP, where on the basis of DNA evidence alone, and of course corroborating circumstantial evidence, there was a conviction granted. I will not go deeper into that. Yes. Now coming to the facts of that particular case. Here for the first time, the Supreme Court has said that because the custody is not proved, the chain of custody is not properly proved, we are acquitting the accused. It is true that PW number so-and-so has stepped into the witness box. His report regarding DNA was exhibited. However, merely exhibiting a document does not prove its contents. The record shows that all the samples relating to the accused and relating to the deceased were seized by the investigating officer on 2 particular dates, and they were sent to CFSL on another date. During this period, and the dates are quite, there's a lot of delay. During this period, they remained in the Malkhanov police station. Under the circumstances, the possibility of tampering with these samples collected could not also be ruled out. Neither the trial court nor the High Court has examined the underlying basis. And this is very important. Neither the trial court nor the High Court has examined the underlying basis of the findings in the DNA report. So you have a DNA report, but again, it's not a magic bullet. The underlying basis for arriving, the methodology of arriving at that DNA finding is also going to be looked at. Nor have they examined the fact whether the techniques were reliably applied by the expert. In the absence of such evidence on record, all the reports with regard to the DNA profiling become highly vulnerable, more particularly when the collection and sealing of the samples sent for examination were not free from suspicion. So you have a different note being struck by Supreme Court where it says that be careful, this is not a magic wand, you have to have checks and balances. I'm just coming to the end of my talk, and the last 2 judgments that I'll be talking about is one of Inayat Ali versus State of Telangana. We are moving closer now, so we are in 2024, and the Supreme Court again strikes a cautionary note. Paragraph 11 is the only paragraph that I would want to highlight. This is again a paternity suit. It is not a criminal trial. It's not a criminal investigation. The substance, and it's very interesting. The substance of the complaint was not related to the paternity of the children of the respondent. Now, what I'll just give a background. This was a case of FIR against the husband and the brother-in-law. for 498A and other allied offenses. In the midst of the trial, the wife files an application for directing DNA profiling of the brother-in-law. Okay, in the midst of a criminal trial, the wife directs an application or makes an application for asking for the DNA profiling of the brother-in-law who's an accused with the blood samples of her daughters, because she alleges that there is an affair, and her daughters are born, and the father of those daughters is the brother-in-law. Now, this is something which is not germane to the case at hand, and which is exactly what the Supreme Court comes down very heavily on. It says the substance of the complaint was not related to the paternity of the children of the respondent, but the question was whether the offenses under the provisions of the IPC, etc., were committed against her or not. The paternity of the daughters of respondent is a collateral factor to the allegations on which the criminal case is otherwise founded. On the basis of the available materials, in our opinion, the case out of which this proceeding arises could be decided without considering the DNA test report. And then it says something which is very interesting. It says merely because something is permissible under the law, it cannot be directed as a matter of course to be performed, particularly when a direction to that effect would be invasive to the physical autonomy of a person. So here it widens the scope of the use of DNA. You can't use DNA as a kind of a magic mantra for the asking every time an application is made. Yes, DNA is very effective, very efficacious, so let's employ it all the time. No, that is what the Supreme Court is saying. The consequence thereof would be not confined to the question of whether such an order would result in testimonial compulsion, but encompasses the right of privacy as well. Such direction would violate the privacy right of the person subjected to such tests and would be prejudicial to the future of the two children who were also sought to be brought within the ambit of the trial court's direction. Then 2003, of course, we are traveling a little, we are doing a time travel here. I had forgotten 2003. So there's one Sharda versus Dharampal, where Supreme Court has examined the question of whether directing a DNA test would be violative of Article 21, which is something which I wanted to bring to your notice. And subsequently, it was held that DNA test, if in the face of a strong prima facie case, which is made out in favor of doing a DNA test, is not violative of Article 21. So again, it's not a blanket yes, it's a yes with a rider. Now coming to the last judgment, which the forensic scientist has already alluded to, but I would like to read it because all of us are going to be affected by these. And this is perhaps the most comprehensive guidelines that the Supreme Court has laid down in my limited understanding and my knowledge of how the law on this aspect has evolved. So I'm actually going to read them. These are guidelines and they won't take more than 2 minutes. The Supreme Court, after considering all the aspects, all the positives, negatives, the aspect of chain of custody, the relevance of DNA as a tool, efficacious, not efficacious, and all of that, gives some guidelines which are very interesting. This lack of a common procedure, it says, to be followed is concerning. As such, we issue the following directions, which shall be followed henceforth. And this is as of 15th of July 2025. So just a few months ago. We issue the following directions, which shall be followed henceforth in all cases where DNA evidence is involved. 1. The collection of DNA samples once made after due care and compliance of all necessary procedure, including swift and appropriate packaging, including A, FIR number and date. So documentation it's speaking about. FIR number and date, section and the statute involved therein. Details of the IO, police station, and requisite serial number shall be duly documented. The document recording the collection shall have the signatures and designations of the medical professional present, the investigating officer and independent witnesses. Here only we may clarify that the absence of independent witnesses shall not be taken to be compromising to the collection of such evidence, but efforts should be made to join such witnesses wherever possible, and the eventual inability to do so shall also be put down on record. That is the guideline number 1. Guideline number 2, the investigating officer shall be responsible for the transportation of the DNA evidence to the concerned police station. So here it is commenting on the chain of custody. Concerned police station or to the hospital concerned, as the case may be. He shall also be responsible for ensuring that the samples so taken reach the concerned forensic laboratory with dispatch, and in any case, not later than 48 hours from the time of collection. Should any extraneous circumstance present itself and the 48 hours timeline cannot be complied with, the reason for the delay shall be duly recorded in the case diary. Throughout, the requisite efforts be made to preserve the samples as per the requirements corresponding to the nature of the sample taken. Guideline number 3. In the time that the DNA samples are stored pending trial, appeal, etc., no package shall be opened, altered, or resealed without the express authorization of the trial court acting upon a statement of a duly qualified and experienced medical professional to the effect that the same shall not have a negative impact on the sanctity of the evidence, and with the court being assured that such a step is necessary for the proper and just outcome of the investigation or trial. Guideline number 4. Right from the point of collection to the logical end, that is, the conviction or acquittal of the accused, a chain of custody register shall be maintained wherein each and every moment of the evidence shall be recorded with counter signatures at each and every step, stating the reason therefore. This chain of custody register shall necessarily be appended as part of the trial court record. Failure to maintain the same shall render the IO responsible for explaining such lapse. The Director Generals of Police of all the states shall prepare sample forms of the chain of custody register and all other documentation directed above and ensure its dispatch to all districts with necessary instructions as may be required. And this, of course, at the end, there is a note that the registry is directed to send a copy of the judgments to all high courts, all the DGPs of all the states, police academies, etc., etc. So I think by far the judgment is of Kattavelai, Devakar versus State of Tamil Nadu. I'm keeping all the judgments here so that you can later on have an opportunity of going through them. So in 2025, in July, as of July, we have a list of comprehensive guidelines coming from the Supreme Court. Last but not the least, there was a truncated effort by the legislature. I will call it truncated because there was a bill which was called as the DNA Technology Use and Application Regulation Bill 2019, which was introduced in the Lok Sabha on 8th of July 2019. It reached the standing committee somewhere in 2021. There was a lot of opposition to this because it raised issues of invasion of privacy and also documentation, etc. And it was withdrawn by the government on July the 24th to 2023. So you can get this bill online. In my opinion, this bill was drafted very exhaustively and comprehensively. Of course, there is always scope for improvement. Perhaps a new bill would be in the offing and the government can think about introducing a bill so that, or a legislation, so that all of this, which are now collated in the form of guidelines of various courts and the collective wisdom of judges everywhere, is somewhere crystallized into a statute which would be of immense help to everybody. With that, I come to the end of what I wanted to sort of share with you today. I thank the management, the wonderful organization that has been done on behalf of the GSLCA. And thank you very much and have a nice evening.
We are grateful to Justice Chavan for his erudite exposition, drawing not only from his illustrious career at the bar, but also from his vantage point on the bench. At this juncture, it is my honor to throw upon the floor for interactive session. The session will be moderated by Justice Sriram Sirsat. May I request Justice Sirsat, Justice Chavan, and Ms. Tiwari to rejoin us on the stage, please. For the participants online, if you have any questions, please please click on the react button and raise your hands. Thank you.
Before it starts, just 2 minutes. Thank you, madam, and thank you, Justice Chavan. A great insight to the evolution of DNA. Madam has taken us to the entire process of evolution, how it started in the year 1990, then what is the position today, a continuous improvement in this field. Earlier, the process was very lengthy. Now, how the extraction is done, what is the method, which kits are used, and how the analysis has been interpreted. She also took us to various case laws on this subject. Then her submissions were that there has to be a collective efforts on the behalf of the law enforcement agencies, then the scientific analysis department, and the courts. So there has to be basically coordination within which all the three aspects are there. Then she also took us to the latest case laws of Kathawali, where the importance of chain of custody and the timely transport to the FSL has also been emphasized. Justice Chavan also, in his excellent manner, has taken us to the various case laws, right since the beginning in Kuni's case, then Priyadarshini's case, then the judgments of Kishan Bhai, and the judgment of Rahul versus State of Delhi, where it was emphasized that the court is not going to take it just like that, but there has to be other things like collection and preservations. And if not done, it will have its own consequences. Then the latest judgment of Kathawali is where the chain of custody has to be proved. So with all this, if anyone has questions.
So recently, around 2 months back, the UK claimed to have generated DNA, artificial DNA. So I would like to know how this in future. So we treat the DNA as a conclusive proof in identifying the culprit. So how we look at in the future?
Thank you for your question. Like you asked, they have generated an artificial DNA. So as the name suggests, it is artificial, and the evidence which we are getting, it belongs to a person. So obviously that DNA cannot be same, whether it is artificial or it is of human. There has to be differences. There will be differences. And on the basis of those differences, we are going to interpret our results.
It cannot be identical. When it is generated, it can be identical.
So for that, you have to give your data, your DNA data. So now, there are databases. So there are terms and conditions where you cannot share, nobody can share your data, your DNA data to anybody. So again, then the legal things comes into the picture. If somebody is stealing your data, your DNA data, then the legal terms are there, I think, for that.
The DNA mapping or DNA probing.
Sorry?
It can be considered as a conclusive proof.
Yes,
of DNA.
obviously, like I said, see, in a crime, there must be an involvement of a accused or a victim is there. So we are getting the blood sample from that accused and from that victim only.
The question, I believe, is whether it can be said to be a conclusive proof. Is that your question?
So yes, it is a conclusive proof.
I would like to answer to that. So if you look at any scientific testing methodology, as it evolves, it also creates or presents challenges. I wouldn't say problems, I would say challenges. So this is one of the challenges that is thrown up, creation of, let us say, an artificial DNA. I'm sure scientists are going to find some way to see to it that it will not come in the impediment or it will not act as a deterrent to the crime scene investigation. I am quite sure that some kind of a solution will be found out in that aspect so that the legal sanctity of the whole thing can remain unabated.
Mine's a practical question to Ms. Tiwari. So, in case you've mentioned wherein there are probable matches of DNA, especially mitochondrial DNA, say there is an old unidentified body, a sample. You have hair follicles wherein if you don't have the hair root, you're forced to rely on mitochondrial DNA passed on the matrilineal line till whatever generation. Now, the ideal situation, if you have such a person and you have a probable relative, would be to trace back to the last known matrilineal relative and establish a line. That is the ideal situation. In a real situation, wherein you cannot trace to the common matrilineal relative with mitochondrial DNA, you have an unknown sample, you have a probable relative. How many generations up, that is above, and how many relatives removed would you try to test in order to establish your probability?
Thank you for your question. If I understand your question well, so you are saying ki from how many generations we can derive this. So why do we need that? My question is that, see, like, first of all, there is a body from which we are generating a mitochondrial DNA profiling. Okay. Now must be some claimant, and who is saying ki, okay, I am her sister or I'm her mother. If that person is a mother, then obviously we can go for the STR. If that claimant is the sister, then we will do the mitochondrial DNA analysis. And if it matches with that person, we can identify, okay, it belongs to the maternal lineage of this particular family. So now the case is solved. Why we are going to trace the all generations? What is the need of it? That is my question. I mean, because we are not doing research. We are doing the analysis of the exhibits which are submitted by the police. Now, as per your question, now police has to collect all the samples.
No. The only reason I asked is because of a practical case wherein it was used. In case of King Richard III, who was identified in Leicester, they traced back to the common matrilineal relatives, came to know, okay, three probable relatives were taken, and then they established the probability.
I understand. But if there is such kind of scenario, we can do that. But in India, most of the cases which we are doing currently, firstly, I would like to mention that currently we are not doing mitochondrial DNA sequencing in the field of forensic science. No case has been reported on the basis of maternal mitochondrial DNA. But in future, let's say if we are doing that, so it is going to be a very lengthy process and again laborious also. So we would be focusing more on the exhibits which are submitted to us. That could be done. But when we are talking about the research perspective, here we are not doing research. We are focusing on the exhibits which are submitted. And ultimately what we want the justice. We want the report to be submitted as soon as possible. So we'll stick to these standard procedures. We follow those standard procedures. And if your question actually belongs to the research field, which we are not doing, being a scientific expert in FSL. Thank you.
Yes, anyone?
Hello. So I have a very simple question, in fact, a layman's question. Mostly we have seen that the DNA analysis have been effectively used. We see at the time of investigation, it points finger at one person. But when it comes to trial, most of the time, rather when it should have been a conclusive proof today, it fails to even be a corroborative piece of evidence, maybe because of procedural flaws in between. I would like to know from Justice Chauhan, where do we fall short? Do we need something at the administrative level or revisit in a judicial approach or something at the legislative front? Because ultimately, the whole purpose is to ensure that the culprit is behind the bars. Thank you.
The answer is also very simple, since the question was very simple. The answer is that efforts of all three institutions need to be put in. The judiciary needs to look at it with a different perspective, with the perspective that yes, scientific evidence is here to stay and is a great tool to aid the ultimately the criminal justice system. The laboratories on their part have to do their best so that the methodologies don't fail, the chain of custody remains intact, The investigating machinery is also tasked with the onerous responsibility of maintaining all of that. So the answer to your question is very, very simple. It is yes, participation and synergetic interaction of all three institutions will have to be there.
My question is first to Ma'am Tiwari. When you spoke of the importance of expeditious delivery of the sample to the testing agency, and you referred to the fact that if at all there is a delay, there is a possibility of the sample deteriorating. Now, does it depend on the nature of sample? For example, if it's a hair follicle, is it also subject to external elements that can deteriorate, or it all depends on which part is the sample attached to? That's the first question. Yes, I will also get a legal perspective on that. And the second question will be whether, in terms of the technology and technique, where do we stand internationally? Do we have the best technique and technology internationally from investigation standpoint? And also, if Honorable Judge Chavan can also elucidate on the international legal framework, if at all, which is not possibly available in India, which can give it more teeth.
Thank you for your question. Your first question was, like I said, the time period, how long the police agencies are taking time to submit the exhibits from when it is collected from the crime scene to submit it to the FSL. Obviously, it affects a lot. And again, it depends upon the nature of the exhibits which has been collected. Let's say if it is a liquid blood and it is not stored properly. Now, liquid blood is there. If it is on crime scene, it has to be collected on a gauze, and then gauze has to be dried, and then keep it in the paper envelope. Let's say if you are collecting the gauze if you're collecting the blood on gauze and you're keeping it without drying it, then obviously there will be a fungal growth because of the moisture. Okay. So again, when we are collecting any evidence, the preservation plays an important role. Sometimes the exhibits are submitted after 1 year, but we are able to get the DNA profile. Why? Because those were preserved in a proper manner, in a proper condition. So let's say if there is a fetus has to be preserved in 4 degree or -20. If you don't have -20, 4 degree would be fine. So, and then avoid formalin, use normal saline to preserve the fetus. So these are the few points while collecting and preserving the exhibits. If we keep these points in mind, then obviously it will support the forensic expert to generate the DNA profile out of it. And your second question was, sorry.
Yes, in terms of international techniques.
Yes. So yes. So in DNA, whatever we are using, the techniques, the technology, it is all globally recognized and standardized techniques. So when it comes to DNA, there are standard procedures and we have to follow those procedures. We cannot do anything that is not as or up to the mark of the standing procedures. So like you said, we have all the technologies as compared to the which are present globally. The kits which we are using, these are globally recognized kit, validated kit. And again, when it comes to the DNA, it has to be validated. So we are using the kits, we are using the instrument which are globally validated and recognized. So yes, we have that standard. We are maintaining that standard, whether it is a Goa FSL or any FSL of India. We have the latest technology also in Delhi, in CDFD Hyderabad. So we are into research also. So I think, yes, we are on that platform. We are not lacking anywhere except the database, which is, again, it is in process.
Just a small clarification. So the vulnerable point in the chain of custody is only in the collection and preservation, but the final testing is in that sense quite conclusive. There cannot be any vulnerability there in the final machine testing.
Yes.
Because I think the main vulnerable points are the actual collection and preservation. But the final testing as a machine testing, does it have also some vulnerabilities or
actually
points of
because,
contention?
As I said, all the machines are validated, all the kits are validated. The things which we avoid during doing the methodologies or doing the practical things in the lab is avoid contamination. For that, we have the standard protocols and we are following it. Like when you are in the lab, you have to wear apron, wear gloves, wear cap, mask. So to avoid those things which can create some problem or which can, weaken our report, we are taking measures for that, and then we are doing the testing in the lab. And again, the instrument part is the validated one. There is no chance of any error from the instrument. And manual handling, yes, the expert is quite expert in that particular field. So yes, whether this belongs to me or any other scientific expert, he or she is always taking care while handling the DNA exhibits. Because again, it is very, the small, like sir was telling, the small DNA is can create an entire profile. So if there is any contamination or something is missing, then again, it can change the complete case. Thank you.
I'll just add to what Madam was saying. One more vulnerability point is the aspect of investigation. So one is, of course, the collection, the maintenance and preservation and the testing. But what happens after that? It goes in the hands of an investigating officer who then takes it forward and utilizes it as a piece of arriving at some kind of finding and placing that finding within the four corners of law, and in that manner of speaking, in the final report that he prepares. So I think there must be more of these sessions where we bring in police officers, where the forensic scientists interact with police officers in the way they are interacting with lawyers and the criminal justice system this side of the fence. There must be an interaction with the investigating agencies, not the higher echelons of the police officers, but those people who actually investigate crimes at the PI level, at the PSI level, at the station duty house officer level. So I think that would also help in removing the vulnerability that exists in that area also.
So in short, there has to be proper coordination.
My question is for Ms. Tiwari. You spoke about the quantification stage with PCR, and you spoke particularly about inhibitors in DNA samples. What I wanted to ask is what are different examples of inhibitors in DNA samples? What would cause inhibitors to be present in DNA samples, and to what degree would these things compromise the integrity of a sample?
Thank you for your question. So like you asked, what is inhibitor? So inhibitor is something which is inhibiting that any particular thing. When we talk about the DNA, it means it is inhibiting the DNA profile. So we are not getting the DNA profile completely. What could be the inhibitors? So there are a lot of things which can act as an inhibitor. And let's talk about the soil. If you have collected a blood sample from the soil, you have made a gauge, then soil components, they can act as an inhibitor. Second, if the stain is present on the cloth and that cloth is releasing dyes, so that dyes can act as an inhibitor. Most of the cases where blood stains on present on denims, jeans pant, so that releases dye and it inhibits the DNA profile. So there are a lot of factors which can affect, and again, there is a fungal growth. If there is a fungal growth on that particular exhibit, again, it will inhibit the DNA profile. Because the kits are specially made for the DNA of human. So if there is any other thing present in that particular sample, it will not, the primer will not bind properly with the sample, with the desired strand of the DNA. And again, if primer is not binding, amplification is not possible. Amplification is not possible, again, we are not getting the DNA profile. So there are factors which can act as an inhibitor, like I said. Thank you.
There is someone online who wants to ask a question.
Am I audible?
Yes, yes.
Yes. My question is actually to Madam Tiwari. And the question is, how long, once a DNA sample is collected, how long can you preserve it? Because in most cases that I have actually come across, the DNA samples get degraded because of non-preservation. In case of an unidentified body, or in case of a crime which has gone undetected, in case of missing persons who are later discovered in form of maybe in case of some body parts or bones, etc., like we have seen in Sheena Bora's case. Now, how long, madam, can a DNA sample be preserved? And what are the current facilities which are available with you as a lab for preservation of samples? Now, there's also a corollary question. I'm so sorry. Is that in case of samples which are collected and preserved, then as a defense lawyer, if I want to dispute those tests, then an independent testing, if the court orders so, then in that case, I will have to then seek those DNA samples from you, even in case you have prepared some report and maintained with you. But if the samples themselves have got degraded, then whether the defense gets prejudiced. This was my question.
Thank you for your question. So like you said, for how long we can get the DNA from any exhibit? So it depends. Again, sometimes there are possibility you can get the DNA even after years. Sometimes there are cases when the crime has been done like 1 month prior and we are not getting the DNA. So what is there which is affecting the DNA? Again, the same thing, collection and preservation. So if collection is properly done, DNA sample can be preserved for years. If there is a liquid blood sample or semen sample, it has to be dried, because we cannot leave any scope for the humidity or moisture that can, that can initiate the fungal growth. We have to avoid that, which is quite not possible in India, especially for police side, I would say, because they do not have the storage area. But in our lab, as your question was, do you have a proper storage facility? Yes. In our lab, we have cold storage. We have -20, we have -40, we have 4 degree. Everything is stored in proper temperature. If it is sample of fetus or tissue material, we are keeping it in -20. Our kits, we have to keep our kits which we are using in -20. The exhibits which we are isolating, that has to be at 4 degree. So temperature plays a crucial role when we are talking about the extraction of the DNA or getting the DNA profile out of it. From the initial step at the beginning only, when you start isolating, again, we have refrigerated centrifuge. So that refrigerated centrifuge will provide the optimum temperature to those samples which we are extracting. Again, the PCR machine, it has, as I was telling in my PPT, there are cycles of cooling and heating. So when the cooling heating cycle is done, that particular instrument will automatically reach to the 4 degree and the samples will store on that particular instrument till the time you are switching it off or you are taking it out for the further process. Then the kits, the chemicals, the normal chemicals, the isolation chemicals, everything has to be on optimum temperature, which starts from 4 degree and goes up to -80 degree. So in lab, yes, everything is there, but I understand there might be some limitations for the police officials because they do not have the proper area to store the exhibits, or I'm not sure. I'm just giving my part this clear that from in the lab, there is a lot of space and there is proper storage facility available to store the sample at proper temperatures.
I believe the question was that how long it can be preserved.
Like I said, it can be,
For instance, if you can give some examples.
for example, if it is preserved in FTA cards. So after a year, we can get the DNA profile from the FTA card. Like if the blood is preserved on the gauge, dried gauge, after 1 year, 2 year, you can get the DNA profile. If it is a fetus and it is preserved in -80 or -40, you can get the DNA profile. If it is a bone has to be stored in a dried condition, because if tissue is attached to a bone, it will start degrading because tissue is there, the cell will die, it will start lysing, and then it will affect the DNA that is present inside a bone. There are cases where we are receiving the bone and along with the bone, there are tissue wrapped around it. Muscles are there. So that starts degrading the DNA which is present in the bone also. So again, the preservation, as I said. So if it is, the preservation has been done correctly, we can get the DNA after years also. Like there are cases we are getting from the bone remains, like 1,000 years of, we are finding, these Yeah, fossils. Yes, yes. We are doing the fossils, DNA, we are getting it from the fossils. How? Because DNA is there. If it is stored properly, then obviously we can get the DNA profile out of it. But if the storage is not up to the mark, then we cannot help in that and we cannot get the DNA profile. And like, sir, you were saying, it is not a magic wand. So we cannot get it, okay, there is a blood, you can get it. No. If you are not collecting it properly, you're not preserving it, and you're not sending it on time, then again, limitations are there. Thank you.
Yes. Anyone else?
Am I audible?
Yes, yes.
Yes.
Yes, yes. My question is that can we say that once we get a standard result after analysis, preservation was perfect?
Sorry? Can
we say that after we get a result, desired, I'm not
Yes,
saying
yes.
desired, standard result, can we assume that preservation was perfect?
Yes, yes, we can say that, because in most of the cases, we are getting the exhibits which are properly preserved, and we are getting very good DNA profile out of it. So we can say if the preservation has been done properly, then again, we are going to get a very good DNA profile. And there has to be stain also, sir. Let's say if you have preserved a gauge and there is no stain, then again, no DNA profile. So if there is a stain, there is the body fluids on that particular exhibit which are sent to the FSL, DNA profile can be done.
I extend my heartfelt gratitude to each one of you for participating with enthusiasm, thereby rendering this session both lively and enriching. As a humble token of our appreciation, may I invite Advocate Uddesh Naik Desai to present a memento to Justice Ashish Chavan. Ladies and gentlemen, please join me in offering a resounding applause to Justice Ashish Chavan, please. Likewise, may I invite Advocate Nigel J. Fernandez to present a token of appreciation to Ms. Deepika Tiwari. A round of applause, please, to Ms. in Ms. Tiwari's honor. I now call upon Ms. Shabnam Sheikh, the Member Secretary of Goa State Legal Services Authority, to kindly deliver the vote of thanks.
Honorable dignitaries, esteemed guests, senior counsels, advocates, public prosecutor, assistant public prosecutor, and all present here. It is my proud privilege to propose vote of thanks on behalf of Goa State Legal Service Authority and the Goa High Court Bar Association for the workshop on scientific evidence relating to DNA, legal and forensic prospect. We are deeply thankful to Honorable Justice Valmiki Menezes, Judge, High Court of Bombay at Goa, and Chairperson of High Court Legal Service Committee, for his valuable encouragement and constant support to this initiative. Thank you, sir. A special word of thanks to our dignitaries, speakers, Honorable Justice Ashish H. Chavan, Judge, High Court of Bombay at Goa, for his insight presentation on the legal perspective of DNA evidence. Thank you, sir. I thank Deepika Tiwari, Scientific Officer, for her enlightening presentation on collection and analysis of DNA forensic evidence. We are equally grateful to Justice Sriram Sirsat, Judge, High Court of Bombay at Goa, for moderating today's interactive session so ably and making it engaging and enriching. Thank you, sir. We also acknowledge the presence of Principal District and Session Judge North and South and all the judicial officer, both present physically and virtually, whose participation added great value to this workshop. I also thank the registrars of the High Court. A word of appreciation is due to Director of Prosecution, Public Prosecutor, Assistant Public Prosecutor for attending workshop physically and virtually. I also thank Inspector General of Police, along with all the police inspector and DYSPs attending virtually for the active involvement. We extend our special gratitude to Ashutosh Apte, Director of Goa State Forensic Science Laboratory, who has been the key person in conceptuating and organizing this workshop. We are thankful to the members of Goa High Court Bar Association and President and members of Bar Association from North and South Goa and for their presence. I also thank the media person for the coverage. Last but not the least, our sincere thanks to the technical team of High Court of Bombay at Goa for the seamless support in ensuring that this event was conducted smoothly, both physically and virtually. I also thank Advocate Melissa for the comparing the program for today's workshop. Our next workshop is on 15th of October. I require all the present today also to remain present for our next workshop. No doubt, I will send a reminder. I will remind you and also send the program schedule. Thank you so much.
With that, we draw this session to a close. Thank you all for your gracious presence. Travel safely and may the remainder of the weekend be both contemplative and fulfilling. This is your host, Melissa Simoy, signing off. Have a good evening.